But the vicious cycle that we've seen consistently is because you wonder, you're like, hey, this management company keeps, sort of working for these associations. Everyone knows that they're a horrible management company. Why do they stay tethered to these associations? And often, this is a very common practice, unfortunately, is the association attorney will turn a blind eye to the management company. Why?
Yes, please.
Why? Because management companies are a great referral source for that law firm or lawyer. I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Bad HOA. Welcome back to the show. Again, we have Marty, the producer.
Hello, good morning, good afternoon. Or how do they say it in the Truman Show? Good afternoon, good evening, and good night.
Nailed it.
Yeah.
Yep. Welcome. And today's topic actually is directly from a comment that one of the viewers left for us.
Yes, I was excited about this one. And one that popped up that we get, I see confused very often in the space.
Well, what's great about this comment is that it hits a pain point that I would say a lot of homeowners deal with all the time. And a lot of lawyers don't understand this concept. Even good real estate lawyers, I see them just miss the mark time and time again. So I think this show is perfect from an empowerment perspective and just to clear the air around a very specific, somewhat nuanced, like I said, pain point.
Yeah. Well, let's get into it.
All right.
Introduce the topic.
All right. Management companies. Bad management companies. Our show is called Bad HOA. This is Bad Management Company.
Okay.
101.
So I'm going to give you a little bit of a preview of a Reddit post I just saw.
Okay.
So person went on there and said that they went to the property management company, homeowner.
Okay.
Says, I want financial records.
Okay.
Give me these financial records. Property management blew them off. And they were very, very upset about it.
Rightfully so.
Yeah. And I just thought to myself, from doing this the whole time, they don't have an obligation directly to the homeowner. They have an obligation to the board, which was interesting because there is like this huge misconception on who does the property management work for, what's the difference between the property management and the HOA and that whole structure. So how about you break down the layers for us?
Let's start unpacking this thing.
Yeah.
And we unpack it legally.
Yeah.
I wish I had a whiteboard because that's probably the easiest way to do it. But let's back out.
That's for season 3.
Season 3 will have a whiteboard. But look at it. Association, legal entity made up of members of the community, typically voted in, right?
An HOA board.
An HOA board.
Yes.
And that HOA board in and of itself has direct contractual ties to the homeowners. Think governing documents.
Yep.
Those are the contractual obligations. Those are legally enforceable. And so it's association on one side, that's a party as entity. And then on the other side, it's the homeowner.
Yeah.
So very strong contractual rights. Then on top of that, you have fiduciary. We've discussed fiduciary before.
Unpack it a little bit, though.
Fiduciary is a heightened relationship or a heightened obligation. And what that really means is the association must make decisions that are in the best interest of the community. They can't be self-interested. They have to look at the community at large, and the standard of care is heightened.
I can hear the laughter on the other side of the camera right now with can't work in self-interest.
Right. Exactly. Because typically bad HOAs, it's all self-interest, right?
Yeah.
So then you take a management company, okay?
What does a management company do? What's their role?
So let's look at it this way. A board is made up of volunteers.
Yes.
And those volunteers don't necessarily want to collect fines. They don't want to deal with the common area. They don't want to assess. They don't want to keep financial records necessarily.
They don't want to run the day-to-day.
Correct. So often an association will outsource to a management company. So that management company becomes a vendor to the association. It's an agent.
Yeah.
Right? It's contractual in nature. So the association hires a management company, and that's typically memorialized in a contract. And really what the management company is supposed to do is perform the functions that the HOA is supposed to perform, but it's just outsourced.
Yeah.
because you don't expect Billy on the association to be, mowing the lawn or doing sort of the common area maintenance,
Or be a CFO.
or be a CFO, or
Yeah.
do the accounting, or do all the things that sort of go along with running a community.
Yeah.
So it's an outsourced obligation. Now, often, and I'm not going to name any names, but you see horrible management companies, right?
Mm.
You have these top offenders that we see time and time again, especially in California, right? This is all California centric right
Yeah.
now. I'm not going to identify them, but a lot of, I would imagine homeowners listening to this right now, they're probably yelling at the screen,
Yeah.
right?
You know who you are.
And so what happens though is the homeowner gets mad at the management company and starts to yell at, scream at, write a letter campaign against the management company.
Yeah.
And it doesn't move the needle, right? It's not gaining any traction. And sometimes they'll actually bring in a lawyer, and I've seen good lawyers make this mistake, and they start to go after the management company.
Okay, so clarify that for me. The homeowner hires their own lawyer, or the homeowner, by way of the HOA's attorney?
No,
gets involved?
the homeowner will hire a lawyer.
Okay.
And let's say it's more of a generalist.
Okay.
And they say, you know what? The management company isn't maintaining the common area. The management company isn't responding. The management company has screwed up the fining, and you keep getting fined. So they actually start to drive legal attacks against the management company.
Yeah.
And I think that's one of the greatest missteps I see most consistently. Because if you look at it, if you break it down, the management company is an arm of the association, meaning that misconduct is imputed back to the association. So in other words, the association can't sidestep liability and say, well, sorry, the common area is a disaster. The management company was supposed to do it, but they screwed up.
Yeah.
That does not allow them to defend themselves against that sort of misconduct, even though it was the management company that screwed it up.
Yeah.
So that's, I think, one of the biggest misconceptions. Now, why is that?
Yeah.
Well, if you go back to the original statement that I made, there is a contractual relationship between the homeowner and the association. There's a fiduciary relationship. So when you have a vendor, management company, that's failing to maintain the common area, even though in the CC&Rs, it says that the association must maintain the common area.
Yeah.
Well, now the breach or the violation or the failure to comply with the CC&Rs runs against homeowner to the association. That's the line of attack.
Because the CC&R says it's the HOA's responsibility.
Correct. It's the HOA. Now, even though the HOA outsourced that responsibility, if that is not met, imputed back to the association.
But I'm sure they have their own contracts that between the management company and the HOA.
That's where it gets interesting. Because let's say you do have a management company that consistently is falling below the standard of care.
Yeah.
Right. The common area is in a state of neglect, or their failure to respond, be transparent, all of these things. Right. So a good association, in my opinion, should actually, maybe even go so far as to terminate that relationship.
Yeah.
Find a new management company. If they're not performing, cut them loose. And then let's say it's very egregious. The management company has actually caused a lot of damage to the community. Arguably, that association should be looking at a potential lawsuit against the management company.
When you have an HOA, so the HOA always has, typically has an attorney that they have. Right. Do those attorneys frequently go after property management companies? I know you don't represent that side, but
I love that question because it hits on a sort of this conflict of interest that we see time and time again.
Oh,
and this is where we're also probably going to get a lot of outrage from our homeowners, maybe who've already seen this.
Yeah.
But the vicious cycle that we've seen consistently is because you're like, hey, this management company keeps, sort of working for these associations. Everyone knows that they're a horrible management company. Why do they stay tethered to these associations? And often, this is a very common practice, unfortunately, is the association attorney will turn a blind eye to the management company. Why?
Yes, please.
Why? Because management companies are a great referral source for that law firm or lawyer.
Oh.
Management company gets hired by an HOA, okay? And management company says, hey, you know who's a good HOA lawyer? Fill in the blank. You should use this law firm or this person. Now that law firm or lawyer who represents homeowner associations gets another client. And the conflict of interest that we've seen is the attorney says, no, management company's doing great, even though it's absolutely on fire and everything is wrong. Why? Because you don't bite the hand that feeds.
Yeah. Yeah.
And that's sort of a political reality that's happening, unfortunately.
So you have uncovered this. It sounds like time and time again. I've
seen this pattern, and I've seen this play out time and time again for the last, decade. Absolutely.
Wow.
And homeowners.
Is there any legal recourse there? Is they're not supposed to be working in this sort of conflict relationship?
You don't necessarily have standing to bring that.
Yeah.
I mean, what the homeowner does though when they find something like this out is they start to go after the association. They're alleging breach of fiduciary, typically violation of the CC&Rs, negligence, right? And they're bringing these causes of action against the association because what the association is doing is essentially allowing for a management company to continuously drop the ball. And sometimes my point is that they do it knowingly, right? They allow it to happen. So it is a vicious cycle that I've seen. And I think by at least articulating it, we often say lifting the fog of war.
Yeah.
Sometimes this is going to hopefully add clarity in terms of what's happening. If a homeowner keeps working with a management company and they're not getting any traction,
yeah,
that could be the reason why. Or why is the association attorney not caring? That might be the reason why. Or, you have someone, you've hired an advocate, they're going after the management company, and you're not getting any traction on that lawsuit or that enforcement action.
Yeah.
Well, you hit the wrong target.
Yeah.
Should have gone after the association. That's typically the stronger approach.
Yeah, because the homeowner, according the way it's structured, the homeowner has no recourse to go after the property management themselves. The homeowner themselves do not have a contract with the property management. It's
That's
the
correct.
HOA.
That's correct. Now, there are certain circumstances where you hypothetically could go after a management company, but that's normally in some situation where the management company has stepped outside of their role or their obligation or their agency. And I don't want to get too technical on this, but maybe a simple example is someone from the management company comes over and slashes your tires. Well, it's extreme, right? But again, I'm kind of saying it's outside of how they were retained and brought on, right? Now, if they were brought on, for example, to maintain the common area, that's their job, and they failed to do so.
Yeah.
Association. Go after the association.
But this can get a little bit, there is a chain here that can get a little bit sticky, right? HOA hires property management company hires landscaper, landscaper hires, independent contractors. And it's like the chain of this guy messes up. So he's obligated to the landscape company is obligated to the property management company is obligated.
Yeah. So you're looking at contractual obligations, right? Though, but that agency may very well flow to the third-party landscaper.
Yeah.
So for example, it's, the association hires a management company hires a landscaper within their rights hires a third-party vendor, and that third-party vendor screws up.
Yeah.
That may very well go right back and trace right back to the association.
Yeah.
So it is possible to go after, that whole chain of command.
Yeah.
You can go after the association because of that chain of command or that contractual chain.
So moral of the story, if you have an issue with the property management, you're shooting yourself in the foot or wasting your time, wasting your breath going directly to the property management company.
And, you really need to analyze it from, what is the misconduct? You should be able to articulate it. Is it, failure to maintain? Is it a failure to be transparent, communicative? Empower yourself there. And then once you can identify that, you bring that to the board's attention.
So in the example on Reddit, they wanted a certain level of financial transparency. Okay. They requested it directly from the property management company. Property management company ghosted them.
Okay.
And so they were fired up about it. And I knew just from this, I'm like, why didn't they just go to their HOA, which is a big misconception. So in that circumstance, they should go directly to the HOA and say, I want this financial document or whatever the case may be.
It wouldn't be a bad next step. Now, what could, in theory, happen is they go to the association and say, hey, I need this. This is my request. And the association says, oh, thank you. Go talk to the management company.
Yeah.
And that's where you get the runaround.
Yeah.
Right. And if you're getting that runaround, if you're not getting any traction, that's probably where you lawyer up. We've said that before.
Yeah.
When do you involve a lawyer? And that's not saying you need to go all in on a lawyer.
Yeah.
But at that point, you want maybe a lawyer to look at it, because at that point, you have to understand sort of what your rights are to the documents you're requesting.
Right.
What is well within your rights, what's not within your rights, and that becomes its own analysis. And then, based upon that analysis, you can sort of back into or reverse engineer different legal options at that point.
Is a lot of this, though, with the board just being completely ignorant? Yes, Tom, go ahead and we don't have those, but the property management, go to the property management company. When the person on the board has no idea that, and then you just start this cycle, but it could be a cycle of ignorance.
Yeah. So as I say, ignorance is no defense.
Yeah.
They can't hide behind ignorance. And in fact, they have a fiduciary to know, right? They can't say, well, we don't really monitor the management company.
Yeah.
That in and of itself is problematic, right? And so the strategy to bring it to the board's attention is, I think, very wise and sound. You lay a foundation. You say, hey, dear board, here's 7 things I've requested this management company to do. They've ghosted me on all 7 things. Here are contractually why I'm entitled to this.
But that really goes back to the homeowner needs to know the structure and the laws, because the HOA, the board might not.
Yeah.
I mean, they should, but they might not. And you can go back at that point and say, I'm requesting this. It's my right under the Davis-Sterling Act or whatever it is. And here's the Davis-Sterling Act says, here's how you request it. These financial documents from the HOA, and then they can request it directly. Yeah, and that's the actual legal move that the Davis-Sterling Act outlines.
Well, it tends to be a very direct move, and sometimes it gets convoluted, the management company and the association, and they're sort of treated one and the same when they're completely different and distinct. And just that small point of clarification can be tremendously beneficial to a homeowner. Just understanding they're not one and the same. They're entirely different worlds.
Yeah.
Right? The association is typically who you have the problem with, and the management company is just dropping the ball on behalf of the association.
Yeah.
But your fight is normally with the association. Just keep that in mind.
Yeah.
And the more you can put the association on notice as to how bad the management company is, that is actually putting legal pressure on the association, because now the association has direct evidence, or at least, assertions or allegations that the management company is falling.
So let me ask
you. Failing.
I mean, the property management is failing. I mean, the people that sit on the board are homeowners. Why would they not just assert and to say, you guys are screwing up? My pool, the pool that is my part of my community is not being taken care of, the landscape X, Y, and Z. Why don't they assert their authority? And I'm assuming the answer is a lot of times they do.
Well, yeah, good ones do.
Yeah.
They kick those management companies to the curb.
Yeah.
But with the bad associations or dysfunctional boards, right, you might have other motives. Maybe the management company is doing a great job for their little parcel, their area of the community, and the rest is going south. And why does why does the board care? Right? They should legally.
Yeah.
But we're talking about a dysfunctional one, so they turn a blind eye. Or they're not in it to really better the community. They don't care. It's background noise. They got on the board because they wanted to secure some power, right? And now that they're on the board, they like the role, they like the title, but they're not actually monitoring. They're not, doing their due diligence in the community.
Yeah.
It could be ignorance, right? It could be turning a blind eye. It could be, hey, this doesn't impact me, so why do I care? It could be a lot of things.
Do you ever see the property management companies by like some way of greasing the palms of the board? Yeah.
That happens. Yeah. And normally the fact pattern there is interesting. This is a little bit hard to establish, but you look at industry standard for a management company.
Okay.
And let's say it's, I don't know, I'm just throwing a number out there. This doesn't tether to reality at all. $5,000 a month for this management company. Industry standard. So if I talk to 5 different management companies, they're like, yeah, for the size of the association, you pay us a fee of $5,000 a month.
Yeah.
But then you find one and it's, $6,000 or $7,000 a month. Right?
Yeah.
And so the scam there, or the kickback, is they say, yes, we want to work with this management company. Here's $7,000. And then behind the scenes, they're getting a kickback of $2,000.
Yeah.
Right. So I've seen that sort of play out. And that sometimes plays out in landscaping arrangements. and it actually does happen.
Or yeah, I'll hire you, but you have to for landscaping or pool cleaning. You got to use my nephew, cousin, whatever.
Right. And then there's a whole other element of self-dealing.
Yeah,
that also becomes problematic from a fiduciary perspective. Some of the other ones are, hey, we will hire you. You're going to get the bid, but here's our area of the neighborhood, and we want special attention here. And we actually need you to build out something. We have a common area, grassy knoll, but we want to put in a little bench, a park, some trees, and our budget is X. So I want all the budget to go into my area. So you have that, so you have a lot of problems with the management companies. So, but I hope, today was really to, again, lift sort of the confusing nature of these relationships.
Yeah.
Because once you kind of see it for what it is, I think your approach is going to be much more tactical and surgical.
Yeah.
And that's really what you want. Because again, the last thing you want to do is just sort of yell, attack at something that's not going to move the needle.
You're attacking the wrong source.
Correct.
They might be the ones screwing up, but property management could be screwing up. Yes. But that's not who your fight is with.
Here's another thing too. That management company might be just, receiving your emails, and in your email you say, send this to the board. This is very important information. Deleted. As soon as it hits their inboxes. Why? They don't want to deal with that. Why would they forward a complaint? Now, good management companies, there are good management companies out there. I'm not saying that there's not, but the bad ones, dysfunctional ones, corrupt ones, they're not passing that along.
They might, or the good ones probably get ahead of it.
Correct.
To say, or they probably never let it happen in the first place.
Correct. Or they follow procedure. They comply with the Davis-Sterling Act. They have good counsel. That's a healthy, functioning association. We don't talk about those really because the title of the show is bad HOA. But they do
good
exist.
HOA.
But they do exist. So I think that's all I wanted to cover, Marty. Is there anything else that you think is...
No, I think that was really interesting, and it's something that we see so often on those comments are just people that don't understand the relationship and who their battle is actually with.
Right.
So I think that was helpful.
So great show. And I think it goes to the point that we make over and over again. We do read the comments.
Would you read the comments?
So thank you guys for another great show. And if you haven't done so already, please subscribe, leave the comments, do all the things that people do when they watch YouTube. I think that was it. We don't have merch, but I would say buy merch if we had merch.
Well...
All right, maybe. Okay. How about this? This was made for the show. This is more of a prop, to be honest. But
we drink out of them.
We do. We use them.
Yeah.
So if you like these, maybe we'll start dropping these. We'll start. Maybe that'll be our first merch.
Yeah, we'll just send them.
Yeah, I like it. All right, guys. Thanks again. Until next time.